Justice
Sotomayor?
There's a Munsingware GVR that's being agreed to here. So you're not bound by anything in this case. And our decision there will inform any new decision in the Ninth Circuit on this issue, correct? Whatever analysis we adopt in the Little case will control what happens in a new case.
That is the law, Your Honor, yes.
All right. With respect to the Erie case, there, the 90-year-old man never said he didn't intend to open another business. He just said this business. And that was the distinction we saw. Here, she has said, I don't intend to do this. Now, every other promise that she made in this litigation, that she was going to continue trying out, that she was going to stay in sports, held true until this case and the negative attention she received, correct? To say she misrepresented her intent is going a little extreme when she honored all her previous intents and only changed her mind when new circumstances arose, i.e., the notoriety of this case, correct?
No, Your Honor, nothing changed externally to the plaintiff. The plaintiff's affidavit filed in this court says that there has been negative attention and so forth since the beginning of this case. The only thing that changed is this court granted certiorari, and then after that, the plaintiff said, I want out, and so I will stop playing sports.
Do you dispute that having a case named after you makes your infamy live forever?
No,
you don't think that Brown and any of the other named plaintiffs that we have in famous cases drawn attention to those people as people? Have you studied your law cases? Students do all the time. I think one of my colleagues had a course where they looked at the lives of the plaintiffs. Do you doubt that having a named case with such an eventful event is going to continue attention on this person?
I don't doubt there will be attention, and I confess—
Negative attention.
And I confess I have studied a few law cases, but—
have you studied the people?
To some degree, Your Honor. What I would disagree with is there's no background principle of plaintiffs get to leave the litigation whenever they want. Even Rule 41, even in just the district court, the rule is that once the litigation hits a certain point, you can't leave.
So what you're going to assume, I know you don't want to, that you were to lose this case, you would say that we have to force an unwilling plaintiff who has offered to dismiss with prejudice, promise not to incur this activity again, we would force that person to continue prosecuting this case.
The court did in City of Erie.
That it did there, but is it the right thing to do? We didn't do it in Atchison.
In Atchison, no one disputed that the case was moot. The only question was which Article III question would be decided first. In this case, we dispute the case is moot. We dispute all of the facts that this is based on. This is a formidable burden that Hecox bears. That's from Nike, already be Nike, to show that it is absolutely clear that this conduct cannot be reasonably expected to reoccur. We think, as the district court said in its striking order, that based on the changing history here, based on the past conduct, as Scalia mentioned in his footnote 3 of his City of Erie concurrence, there is a reasonable basis to doubt whether Hecox's current plans are the final plans. And as long as there's a reasonable basis not to credit the current plans, Article III lets the court hear the case.